Hi, welcome back to my channel. Please like, comment, and subscribe. You will need to prove that the vessel was in navigation at the time of your injury. What does in navigation mean? In general, it means that the vessel was afloat, was being operated, was capable of moving, and was on navigable waters. Finally, you will need to show that your work contributed to the work of the vessel. This is a broad term and your attorney can help you to prove this requirement. Just because you are eligible to file a claim under the Jones Act does not mean that you are automatically entitled to compensation. Eligibility means that you are permitted to file a claim against your employer under the Jones Act. Once you are eligible and file a claim, then you must prove that your employer was negligent and that your employer's negligence caused your injury. Longshore and Harbor Workers' Compensation Act. If you are not eligible to file a claim and seek compensation under the Jones Act, you may be eligible for compensation under the Longshore and Harbor Workers' Compensation Act or LHWCA. This is a federal law that provides compensation for medical care and vocational rehabilitation services to workers who have suffered disabling injuries on jobs that occur on navigable water of the United States or adjoining areas. The LHWCA covers more types of maritime workers than the Jones Act, including people in a variety of traditional maritime jobs such as longshore workers, ship repairers, ship builders, ship breakers, construction workers on harbor or dock areas. To be eligible, the worker's injuries must have occurred on navigable waters of the U.S. or adjoining areas, such as piers, docks, terminals, wharves, areas for loading or unloading vessels. Injured workers also may be eligible for compensation under the LHWCA even if they are not traditional maritime workers, but their injuries occurred on navigable waters of the United States. After a maritime accident, it is extremely important to do everything you can ensure that you are eligible to seek compensation for your losses. Report the accident to your supervisor immediately. Do not try to continue working. Seek medical treatment immediately and, if possible, go to a doctor of your choice. You should know that a doctor hired by your employer may not put your needs first. Take pictures of the accident scene and surrounding conditions if you can. Your lawyer will be able to use this information to support your claim. Get contact information from witnesses. It could be hard to find those witnesses later if you are not still working on that vessel. Contact an injury lawyer as soon as possible. Although the Jones Act has a 3-year statute of limitations, it is better to start the process of filing your claim as soon as possible. Common types of maritime injuries. Maritime injuries can vary widely in severity and type, depending on the worker's job and the nature of the task. Some of the following are types of accidents that result in serious maritime injuries. Slip and fall accident, falls from heights, falling overboard leading to drowning or hypothermia. Machine accidents, heavy equipment caught between accidents on docks and piers. Crane accidents, entrapment in an enclosed space. These accidents may result in some of the following types of injuries: traumatic brain injuries or TBIs, broken bones or fractures, muscle strains and sprains, severe bruising or contusions, asphyxia in an enclosed space, toxic fumes poisoning, chemical burns, lost limbs or amputations injuries, overexertion or repetitive motion disorders. A Kentucky maritime injury attorney can help with every aspect of your case, including the following. First, determining your eligibility to file a claim under the Jones Act or the Longshore and Harbor Workers' Compensation Act, and proving that you are eligible to seek compensation under these maritime laws. Filing your lawsuit. Tracking down witnesses and witness statements to support your claim. Gathering evidence to show that your employer was negligent. Third, seeking a reasonable settlement and taking your case to a jury verdict to seek full compensation for your losses. If you were injured in a maritime accident and think you may have a claim under the Jones Act or the Longshore and Harbor Workers' Compensation Act, you should speak with a Kentucky maritime injury attorney as soon as possible about your case. Contact Morgan Collins, Yest and Sawyer to discuss your case with an experienced advocate at our firm. Our lawyers have the Kentucky courage you need to fight for your rights after a maritime injury cases in Kentucky. In March of 2019, someone said that her life would change. He was at the height at work causing a traumatic brain injury. He lost who he was, his ability to do a job he loved a year of his life. The head injury caused a problem with his heart. If he thought the workers' company system is confusing with the whole brain, try it with the half of brain. The firm of Morgan Collins, Yest and Saylor have helped his negotiate through the maze, making sure that his children and he got what he deserved and were taken care a lot. He was not an easy client, angry about his injury and the changes to his personality and the cognitive difficulties. Depressed about the loss of his self and his career made him difficult. Scott Border took what he threw at him and was a staunch advocate through it all. He would most definitely recommend this firm if you need help negotiating the workers' company system. They will have your back. Thank you so much for watching. Don't forget to like, comment, and subscribe.